So here we start the webinar. Good morning, everyone. This is Dr. Sumit Pahwa. I'm the host for the session, so I have to self-introduce. So I'm a corporate lawyer, company secretary with 25 years of experience. And I'm a senior partner with eMinds Legal, which is a boutique corporate law firm specializing in corporate secretarial, corporate legal, accounting, taxation, and payroll with around 60 to 63 professionals. Joining me is Sneha Adlakha and Diksha Pahuja, and I'll just briefly introduce them. Sneha is an associate partner at eMinds Legal. She possesses over 12 years of comprehensive experience in corporate law and compliances, and her areas of practice include Companies Act, FEMA, listing regulations encompassing incorporations, transaction advisory, secretarial audits, downstream investments, pre and post listing compliances, and she's a key contributor to Corporate Law Referencer, a leading book on company law. Welcome, Sneha, to the forum.
Thank you.
Okay. Introducing Diksha. Diksha is a senior associate at eMinds Legal with over 7 years of experience in corporate secretarial and FEMA, and she possesses strong expertise in handling diverse compliance matters and has developed a keen understanding of the practical implementation of corporate laws and regulatory requirements. Her professional experience includes advising companies on Companies Act, FEMA, secretarial audits, board and shareholder compliances, and various regulatory filings. She's also a key contributor of Corporate Law Referencer. So welcome, Diksha.
Thank you, Smith.
Yeah. And as I said, I'm the senior partner with eMinds Legal, the corporate law firm. I'm also co-founder and CEO with Complinity Technologies, which is India's leading compliance software, adding value to more than 1,500 companies all over India, covering 3,000 plus laws, 40,000 plus compliances, 15,000 plus users, and companies like Panasonic, Max Hospital, Oberoi Hotels, Toyota, Yes Bank, and many more listed companies, multinational companies, funded companies are using Complinity as the compliance software to manage their compliances through technology. So I'm one of the co-founders over there. Now, moving on to the topic is a very relevant topic on DPT3, especially on exempted deposits, because the deadline for filing DPT3 is 30th June every year. So we are on 21st May. So I'm sure a lot of professionals, either on the practicing side or on the employment side, would be right now in the process of filling up DPT3s. So we thought we'll do a webinar very quickly and share our experience as well as take a lot of FAQs. Now, about the topic, companies often receive money from directors, banks, customers, employees, group companies, etc., in various forms such as loans, advances, borrowings, deposits, intercompany deposits, etc. Now, certain amounts fall under deposits, and which are, of course, governed by detailed deposit regulations. There are certain categories which fall under exempted deposits, and today our focus will be to talk about exempted deposits. Now, even exempted deposits, as you would know, are not free from compliance requirements, though they are exempted, but the disclosures are required to be filed in e-form DPT3 on or before 30th June for outstanding balances as on 31st March. So today, the experts Sneha Adlakha and Diksha Pahuja will be covering overview of deposits under the Companies Act, especially focusing on the exempted deposits, requirements and filings under DPT3, due dates, obligations, consequences, penalties, practical issues, challenges, and then we'll close with FAQ. So you can, keep on writing your questions in the Q&A box all through the session. Whenever a question occurs to you, please write your question in the Q&A box. We will take the questions towards the end. The timing of this webinar is 12 to 1:30, and we will surely, close within time. We also have a very special surprise or a nice announcement to share. And I'm sure you all will be glad to hear that towards the end. So we'll look forward to having you at the webinar. And in the meantime, I'll just display an opening poll and then we kickstart the session. Just give me a second. Okay. So this poll is just to know you slightly better. What describes you best? We can see all of you having turned in large numbers. So if you can just tell us who you are so that the speakers and the panelists can then customize their presentation according to your needs and background. Yeah, and while you are doing that, in the chat box, you can see our YouTube links, LinkedIn links, the request a demo in case you would like to have a demo of Complinity. There's a demo link, and there's my personal LinkedIn as well if you'd like to connect with me. So you can use these links to sort of connect. And the recording of this webinar will also be in some time available on YouTube, just to share with you. Okay, so we will end the poll here and share the result. So 40% are practicing, 17% CFOs. 1 second, let me just share the result. Yeah, 40% practicing, 17% CFOs, 34% in-house company secretaries, and 8% others. All right. So basically, Diksha and Sneha, for you, it's 80%, 85% company secretary fraternity, either in-house or practicing, half and half, you can imagine. So here we then kickstart the session. Over to you, Diksha, you to start with the session, and then Sneha will take it after that. So Diksha, you may share your screen and start the presentation.
Yeah, thank you, Sumit, for the wonderful introduction. And thank you also for organizing webinar on such an important topic. And I would say a very warm welcome to all the participants who has joined us today. So without taking much time, let me just share my screen. Is it visible?
Yes, visible.
Okay. So the topic for today is filing of e-form DPT3 and understanding and reporting of the exempted deposits. So let us first understand that what is the meaning of deposit. Just a minute. So deposit will include any receipt of money. In the ordinary course of business, company receive amount from customers, from suppliers, from directors, from employees. So company receive money from the various sources. So what does law says about the deposit? So it is about, is my screen visible? Yes, Diksha, it's visible.
Screen is visible. We can see what is deposit as the headline. Yeah, now we can see the para also. Yes.
Okay. So it will include any receipt of money by way of deposit, loan, or in any other form by the company, but it specifically will not include the money which is exempted under the deposit rule under Rule 21C. So the law says that whatever money that you are receiving in a company, everything will be covered under the deposit. However, the government provides certain list of exempted deposit which will not fall under the category of deposit. So, example, you obtain money from the customers, and suppose in a company you obtain 1,000 crore in a financial year from various sources. So, law says that everything, every amount of money that you are receiving in a company will fall under the definition of deposit. However, the law has provided a particular list under which there are specified categories which will not be falling under the category of the deposits. So today we will understand in detail what is the meaning of those exempted deposits. So before that, very quickly, let us just understand that to whom this deposits rules will not be applicable. So number one, the banking company, NBFC, housing finance companies, and any other company which is specified by the central government. So now let's understand that why these rules are not applicable to such specified class of companies. First, their ordinary course of business is to borrow money. If these rules are applicable to these kind of entities, then it will become very difficult for this entity, to comply with the provisions of deposits. And also, there is a separate set of compliances which are applicable to the banking company, NBFC companies, or the other housing finance companies. So now let us just understand very carefully that what is the exempted deposits. So the number one category of the exempted deposits, any amount which is received from a central government or a state government, or any amount whose repayment is guaranteed by the central government or state government, or any amount which is received from a local or statutory authority. So now, if the central government is giving you any kind of funds, whether in the form of loan or in the form of, any money is given to the company, so that money will not fall under the category of deposits, or the money is not directly given by government to you, but the government is giving the guarantee for your behalf. So this amount will also be not covered under the deposits. Now, the second category is if you're receiving any amount from any of the foreign sources. So this will include the foreign governments, foreign international banks, multilateral financial institution, foreign governments on development financial institution, export credit agencies, foreign collaborators, foreign body corporates, foreign citizens, and the person resident outside India. So now if you're receiving any of this amount from any of the sources, so this will not fall under the exempted, under the deposit, subject to the
And
condition that you have to comply with the provisions of FEMA. So now, example, if you are receiving the money from a foreign body corporate in the form of share capital, then you have to comply with the provisions of FEMA. You have to file Form FCTPR. So now, if you fail to comply with the provisions of FEMA, then this amount will become a deposit, and this you have to comply with the provisions of deposits. So you have to be very careful that you are complying with the provisions of the FEMA and all the rules made thereunder to be categorized as exempted deposits. Now, the next category is if you're obtaining a loan or the facility from a bank. So now this will include if you're receiving any amount as a loan. So that loan will be covered under the exempted deposit, and low cover the facilities also. This is not covering the amount is coming. For example, you're obtaining the overdraft facility from a bank, so this will be covered under the exempted deposits. Now let's take an example that if the law would have not covered this facility and you are just obtaining a loan, only the loan is prescribed here in the exempted category, but then if you are taking the overdraft facility, then you would need to comply with the deposits provision. So understand that this each and every word is important, but is given in the exempted category. So both kind of loan or the facility obtained from a bank or the cooperative banks is covered under the exempted deposits. So now next, any amount received as a loan or the financial assistance from the public financial institution, regional financial institutions, insurance company, or scheduled bank. Here also the laws cover the loan, that is money coming directly into your account, or any financial assistance, not exactly in the form of loan, money is coming to your account, but in the form of any other financial assistance from a public financial institutions. Now, a public financial institution also provides you money. It is not registered as a bank, but they work similar to the bank, like they provide you finance. So this will be covered under the exempted deposits if you are receiving any amount from them. Next, now we have covered all amount received from the Indian government or from the foreign government. You have taken the amount from the banks or the public financial institutions. Now the company is raising some securities, that is commercial paper. If you are issuing the commercial paper or any other instrument which is issued by RBI, so these categories will not be covered under the exempted deposits. Now next, if you're receiving any amount from any other company, it may be in the form of shares, loan, or any other amount you are receiving from any company that is registered in India. So it should be a company. Only the word company is covered here. So any category will be fall under the exempted deposits. Now next, you have taken money as share application money or towards the allotment of security. Either the application money or whether the full value of the security will include your equity, preference, or NCDs, debentures, everything will be covered under the security. You received some amount as a share application or security, so this will be exempted. Now the condition here is you have to make the allotment within 60 days from the date of receipt of the money. Now if you are not able to make the payment within 60 days, suppose you have received certain amount on 1st March, then within 16 days from starting from 1st March, you have to make the allotment. That is, you'll get March and April. By 30th April, you have to make the allotment of the securities. If you are not able to make the repayment within 60 days, the only option you have is you have to make the refund of money within next 15 days. In our example, by 15th May, you have to make the payment in amount. But the law says that any other adjustment for that particular amount will not be treated as refund. Suppose you say that he's my customer and he has to make payment to me, and let me do one thing, let me just adjust the amount towards that amount which the other person is required to give to me, to the company. So that adjustment will not be allowed. You have to repay the money in the form of cash only. Any other adjustment or any other thing will not be covered under the exempted deposit. If you are giving any other consideration, then you will fall, that amount will fall under the definition of deposit. So this is the important condition that you should take care. Next, you are receiving certain amount from any person who is the director of the company or relative of the director of the company. So now the important word is at the time of receipt of the amount. So supposingly I have received the amount from certain person. At that time, he was not the director of the company. Later, I say that, oh, I will fall in the deposits. This amount will become a deposit. 1 month later, I realize that and I make him a director. So after 1 month, even though you are making a director, then that amount is already a deposit. So the important condition is you should obtain the amount from a director when from a person when he is a director. So now it's talking about only the amount received from a director of the company, and it is covering any amount received from a director of a private company, which means that if you are a public company and you are receiving amount from the relative of the director, supposedly husband and wife, husband is taking the amount from her wife and he is a director of a public company, then that amount will not be covered under the exempted deposit. You have to comply with the provisions of the exempted deposit. Now the important condition is that if you are bringing the amount as a director, and suppose you don't have money as a director, you borrow it from others. I borrow it from my friend. So law says that is not allowed, because you have to provide a declaration, a written declaration to the company that you have given this amount out of your own funds. You have not borrowed it, you have not accepted it either as a loan or a deposit from others. The condition is that you should bring the amount only from your own sources. Next point is any amount received against the issue of bonds or debentures. Now we have understood that you have received the share application money. Now we are covering the bonds and debentures. This is a category of the loan, a kind of instrument issued by a company. The condition is law says that it should be secured. If you are taking a loan or bonds or debentures, then it should be secured. Then secured as a first charge. If it is, suppose you have a property of 500 crore, so you are giving the security, this property as a security, or that you are taking the charge ranking pari passu with the first charge. Now you have taken a loan of 100 crore on that property, and to the second person you are giving the same property and you are obtaining the other loan of 50 crore. So the condition is it should be ranking pari passu with the first charge, like both the charge holders are having the similar rights, only then it is covered. If you are saying that okay, that second person is not getting the right second, then this will not be covered under the exempted deposit. So it says that it will cover the assets of the company excluding the intangible assets. For example, I'm keeping a security on my goodwill and my brand values, then this is not covered. It should be the tangible assets, my land, my property, my building. It is covering only that amount. The first condition is that it should be secured. Now the second category is if it is not secured, then you are saying that okay, I'll convert this amount into the shares, and the law is giving you time for 10 years. If within 10 years you are compulsorily converting that amount of bonds or debentures into shares, then this will fall under the exempted category. If you say that okay, after 15 years I will convert the amount into the share, then this is not allowed. You have to convert the same into shares within 10 years. So now Now, the thing is that your amount of loan that you are obtaining, that you cannot obtain the amount more than the market value of the assets of the company. Now there are two categories. One is book value, other one is the market value of the assets. So you have to take the market value of the assets, which is assessed by the registered valuer. You cannot randomly say that, okay, my market value of the asset is this. No, you have to take the market value, which is assessed by the registered valuer. Now, the next category is that you have obtained any amount in the form of NCDs. Now, I say that, okay, I will not convert this amount into shares. I will issue the non-convertible debentures. And also, I don't have any asset or property to give it as a security. Then law says, okay, if you don't have any asset and you don't want to convert it into the equity shares, then list that security on a recognized stock exchange. If I am complying with both the conditions, I am giving the NCDs and I am listing the security on recognized stock exchange, then it will fall under the exempted deposit, otherwise not. Moving to next. Okay. Next category is non-interest bearing security deposits received from an employee up to their annual salary under the employment contract. If you're receiving any amount, you provide the valuable assets to your employees and you ask them, okay, provide me the security deposit. Law says that you can receive this amount, but only to the extent of the annual salary of the employee. Supposingly, you are providing 10 lakh rupees to your employee. The only amount that will be covered that you can receive as a security deposit from the employee is 10 lakh. If you are receiving 11 lakh rupees, then this amount will fall in the category of deposit and you have to comply with the deposit provisions. This will not fall under the exempted category. Other important condition is that it should be under the employment contract. You should have the written agreement and the amount of the salary should be mentioned in that employment contract. If you're not complying, if I'm not making any agreement with my employee and nothing is covered in my employment contract, then this exemption will not be available. Now, next point is non-interest bearing, any amount received as non-interest bearing and held in trust. So now, if I receive any amount from my customer and or as a security deposit from any person who says that, okay, you hold this amount on my behalf and repay it to the third party after some time, then this will be covered under the exempted deposit, provided that I should not give any interest on that amount. If I'm taking the money and giving them an interest, I say that, okay, give me the money, I'll pay you 8% interest. So this will not fall under the exempted category. The condition is that it should be non-interest bearing amount. Next thing is, this is very important, that sometimes in the ordinary course of business, we receive the amount from multiple customers. So if we receive any amount as an advance, example, some of my customer is saying that deliver me 100 quantity of the plant and machinery. I am in the manufacturing company and I am manufacturing plant and machinery. I receive an order and customer says that, okay, I'm giving you this advance and after 1 year you just provide me this, and I'm asking him, okay, pay me some advance. So if I'm receiving any advance for supply of goods and it is covering the provision of services, if I'm in a service sector, then I have to make the appropriation of certain such advances within a period of 365 days from the date of receipt of such advance. The law gives me a time period of 1 year, that is 365 days, that I have to make the appropriation of the amount. What is the meaning of appropriation of the amount? That I have to identify the goods and services against which I have received this amount. If the customer says that, okay, this particular plant and machinery I require, so you have to identify that, okay, I have to supply this particular plant and machinery, then this is called appropriation. And this should be done within 365 days from the date you receive the advance. And any advance that is subject to legal proceedings, that set limit of 365 days will not be applicable to it. Now, it is against the goods and services. Second point will cover the immovable property. I supply the land and building and I receive the amount in connection with the immovable property. The condition is that it should be under the agreement or the arrangement. So I say that, okay, you pay me 100 crore today, and I will give you this particular immovable property. So if I have to supply this as per my agreement and arrangement. If I say that within 6 months I will provide you this property, then if I am supplying it after 7 months, then I'm not complying with the terms of my agreement or arrangement. So this will not fall under the exempted deposit. The condition is that you have to comply with all the terms and conditions which is given in your agreement. Now the next point is, now I have received the advance for against the goods or services against my involved property. Next, I am receiving as a security deposit for the performance of the contract for supply of goods or the provision of services. I have given a contract to certain vendor, and I am saying that, okay, you give me the security deposit. Then that security deposit, if I am receiving against the performance of a contract, this will not fall under the exempted deposits. Now I have received any advance against the long-term projects for supply of the capital goods. Again, I'm supplying the plant and machinery. So I provide the long-term contracts. So any advance received towards that will not fall under the exempted deposits. Again, a similar category, that you are receiving the future services in the form of the warranty. You receive any amount. I have the maintenance. I provide the maintenance services. I'm receiving the amount towards that maintenance contract. So that amount that is received, that or the time period which is prevalent as my common business practice, or 5 years from the date of acceptance of the services, whichever is less, I have to supply the services within that period time, within that period only. Next is any amount received or allowed by any sectoral regulator in accordance with the direction of any central government or the state government. If central government and state government allow me to receive certain amount, so that will fall under the exempted category. If I receive any amount towards the subscription towards the publication, whether in print media or in the electronic media, if I am receiving that amount, that will fall under the exempted categories. Now, the next point is any amount brought in by the promoter or by the relative by way of unsecured loan in pursuance to any stipulation of the lending financial institution or bank. Suppose if I'm borrowing money from bank, and bank is putting a condition, okay, I will pay the money subject to the condition that the promoters of the company or their relative are also putting the equal stake to the company, then this will fall under the exempted deposit. The condition is that promoter should bring the amount as an unsecured loan. If promoter is taking any security against that amount, then this will not fall under the exempted deposit. And also, this exemption shall be available only till the time that you are repaying the money to that financial institution. Suppose I have already repaid the money and I still have the amount which is brought in by the promoter, so that amount will become a deposit. I have to ensure that the date I make the payment to the bank or the financial institution, at the same time I have to refund this money to the promoter or to their relative. Here the word relative is also covered. Either the promoter or the relative, as per the definition given by the under the Companies Act, is covered under this category. Now, the next is any amount which is received by the Nidhi company in accordance with the rules made under Section 406 is covered under the exempted deposit. Any amount received by way of subscription in respect of chit fund will also be covered under the exempted deposit. Any amount received under the collective investment scheme, you are complying with the provisions of the SEBI. SEBI has a separate regulation for the schemes. So that collective investment scheme, if receiving any amount, then that will fall under the exempted deposit. Next category is if any startup is receiving any amount through the convertible notes. Now, what is convertible notes? It is a form of loan that you are taking from a person. Now, if suppose you ask your friend, okay, I run a startup and would you like to invest in my company? Then my friend says, okay, why should I trust you? You say, okay, I issue the convertible note. If the startup business runs well, then you can convert that amount, that loan amount, into equity, or I will repay it within 10 years to you. So my friend says, okay, in next 1 to 2 years, I'll see how the growth is going in the startup. So if I issue that instrument to the person, then that will cover under the exempted deposit. The condition is that I should receive the amount of 25 lakh or more in one tranche. If I'm receiving this amount in installments, like I received 10 lakh in first tranche, 10 lakh in second, so and so on, then it will not fall under the category of the exempted deposit. The condition is that you should receive this amount of 25 lakh in a single tranche to be.
Welcome to Complinity Technologies. Complinity is India's leading governance, risk and compliance software helping companies to manage their compliance, contracts, litigation, legal updates, inter-financial controls and more. Complinity is a one-stop shop for all GRC needs. With our proprietary 12 GRC modules and real-time legal updates on 2,000 plus laws and 24,000 plus compliances. All in an integrated platform that is easy to use with automated alerts and risk management capabilities. Is why compliance managers, general counsels and chief financial officers choose Complinity every time. Join the most innovative and prestigious brands that use Complinity. Automating your compliance management. Request a demo at complinity.com.
Fall under the exempted deposit. Now, the next category is any amount received from the alternative investment fund, domestic venture capital funds, or infrastructure investment trust, real estate investment trust, or any mutual fund. Any amount received by any of these categories of company which is specifically registered under the provisions of SEBI will be covered under the exempted deposits. So now with this, I would like to invite Sneha to brief you the further provisions on deposits. Sneha, over to you.
Yeah, thank you, Diksha, for a wonderful session. I think you covered everything in pretty detail, all the definitions of exempted deposits. And you know what was intriguing to look at is one clause caught my attention was the non-convertible debentures. Companies have to list on stock exchanges. So no wonder we see a lot of companies going for debt listing to satisfy that condition, that it's a non-convertible debenture and therefore listing becomes mandatory if they have to be exempted deposit, right?
Yeah.
Yeah. Very interesting session, Diksha. Thank you very much. And over to Sneha. Sneha will primarily cover the DPT 3 form and associated penalties and few more provisions. So Sneha, over to you. You may share your screen.
So is my screen visible?
Yes, visible, Sneha.
Thank you so much, Diksha, for the detailed explanation regarding exempted deposit. As we have understood, the list of exempted deposit is extensive, but not every amount received by a company qualifies as an exempted deposit. So before we proceed with DP3, let's summarize the broad categories of exempted deposits. First one was the government sources. So any grant subsidies received by the company from government, whether it is central or state. Foreign sources like ECB, and money received by the company from foreign banks. Please be ensured that if you are taking ECB but not complying with the ECB guidelines, then it becomes a non-compliance, not just as per FEMA, but in Companies Act also it will be a non-compliance, but because you will be falling into deposit provisions. Then the money received from banking companies, public financial institutions in form of any loan or any facility. Then the fifth one is commercial paper or RBI instruments. We see payment gateways used by a lot of companies, so that is also excluded. Then intercompany amounts, any amount received by a private company from another private company. Please don't make mistakes by taking loan from LLPs. LLPs are not allowed to give loans to private companies because for the private companies, it will not fall under exempted deposit category. So please be very sure while taking loan from a private company. Then is share application money, which has to be allotted within 60 days. Otherwise, it has to be refunded within 15 days. Then we have the category of loan from directors and relative of directors in a private company, subject to that a declaration has been received. Then we have few securities also from which amount can be taken. It can be from debentures and bonds. So there are NCDs, but that has to be secured. And then there are the CCDs, which has to be repaid or converted basically within 10 years. So then we have non-convertible debentures in case of listed companies, employee security deposit, which should not be more than 12 months of their salary non-interest bearing amount. The next is business advances. It is the most critical head because this is the head under which a lot of amount is received by a company in the form of advances, security deposits, then warranty amount. So please be very sure of taking money under this head. And for this, I think there are lots of people from the finance and tax team also has joined. This is the criteria in which you have to come into picture and ensure that all the advances are either appropriated within 365 days or are refunded within the time period. Then there are promoter loans. What newly incorporated companies do is sometimes they take loan from promoters in order to meet their daily expenses. But in that case, please be very sure that Form INC 20A is filed, because you cannot borrow loan before filing Form INC 20A. So all the things are interlinked with other sections also. Then we have the category of Nidhi company, chit fund, SEBI collective investment scheme, startup, who can issue convertible notes by startup. Just because you are newly incorporated, that does not classify you as a startup. You have to take the certificate also. Then the last one is AIF and mutual funds. So this is a summary of exempted deposits. Now moving ahead with the next, which is penalty for non-compliance of deposits. So what is the nature of contravention in this regard? Acceptance or invitation to accept deposit in contravention of provision of section 73 or 76 of the Companies Act, read with rules made thereunder, and failure to repay deposit or any part of their, including interest thereon. Interest is very important. If you are repaying the deposit but not the interest, that is also a non-compliance within the prescribed time period as may be granted by the tribunal. Then the penal consequences. For the company, it is repayment of outstanding deposit along with interest, like I just mentioned. Along with that, there is a fine of 1 crore or twice the amount deposited, whichever is lower, which may even extend to 10 crores. For officer in default, this section is very important because in other sections, we may only be given fine or penalty, but this also leads to imprisonment, which may extend up to 7 years. And fine is ranging from 25 lakh to 2 crore. And in cases where ROC feels that even fraud is involved, then even section 447 of the Companies Act gets hit. Accordingly, while dealing with exempted deposit, proper documentation and compliances are essential. Companies must ensure that all transactions meet the regulatory conditions. Proper disclosures are there in financial records, which are supported by necessary approvals and declaration wherever required. It is also important to stay updated with the provisions issued by MCA and RBI. As professionals, we go to MCA website every day, but we forget that there is another website of RBI in which amendments keep on coming. So please ensure that you are also updated with the RBI guidelines. Companies must exercise great care while classifying amounts under the appropriate categories of exempted deposit, as incorrect classification may lead to regulatory non-compliance, significant penalties, as well as imprisonment. And because imprisonment is involved, the offense involving imprisonment and fine are non-compoundable in nature. Moving ahead with understanding what is DPT-3, because this is a statutory return which we have to file every year. Every professional, every company goes through this compliance every year. So let's see what is DPT-3. It is a statutory return for reporting deposits as well as exempted deposit. In this PPT, we are already only covering exempted deposit, but the form requires both the details. So if you have exempted deposit, you mention about the exempted deposit. If you have deposit also, then both are required to be mentioned. Frequency and reporting of filing form DPT-3. It is to be filed annually for the period 1st April to 31st March of a financial year. Before the amendment, the details were required to be filed as on 31st March. But now the entire detail has to be informed to the ROC, whether it's opening balance or the closing balance. So the entire period has come into picture. Documents required, no mandatory attachment required for reporting exempted deposit. However, if the company wants to give any clarification to the ROC, they can attach a clarification letter in this regard. Statutory timeline for filing this form: on or before 30th June of the financial year. So we all know in the last week of the filing, of any statutory filing actually, there are a lot of technical issues which are faced by the professionals. So I would actually request everyone that ensure that all the data are in time and we complete the filing before the last week, so that in the last few days we do not have to face the technical issues. Now moving ahead with which entities are not required to file DPT3. Diksha has already explained in her previous slides that on which companies deposit is not applicable, like NBFC, government companies, banking companies, because their day-to-day business is this only. But there are some entities on which filing DPT3 is not required. First is government companies, that is companies where paid up share capital held by central or state government or both is more than 51%. Then there are companies which has neither accepted any deposit or has exempted deposit at any time during the financial year. So if you have an opening balance and not the closing balance, please file Form DPT3. Now let me help you with the details required to be filed in Form DPT3. So the contents of Form DPT3 are basic information, which is SIN, name of the company, registered office address, and email ID. So these are the basic details which are required to be filed in almost all the form. But what is different is objects of the company. This does not get pre-filled on its own. We have to mention the objects. So in that, please mention the main objects of the company, and there is also a word limit. So you don't have to just copy paste the main objects, you can shorten it, but please ensure all the objects are informed to the ROC. Now moving ahead with the contents of Form DPT3, which is particulars. In this category, all the exempted deposits are mentioned, so you can choose under which head that amount will go. Please don't be confused with the word details of loan. The form mentioned loan, but here you have to mention all the amount which has been received by the company, whether it is from central government, foreign governments, promoters, directors, any advances from customers, everything. First is DPT3 requires opening disclosure at the beginning of the financial year. Then it also requires additional amount during the year. For example, if you've taken loan of 10 lakh in the beginning and then in the year you receive 5 lakh, then additional loan is required to be mentioned. Then there is repaid during the year, any amount which is repaid during the year, any other adjustment which may be in the form of interest capitalization, conversion, write-off, exchange fluctuation, etc. And closing balances at the end of financial year. One most important thing regarding opening balances, when we file DPT3, we usually file it on the basis of provisional financial. But next year, when we are filing DPT3 again, please ensure your opening balance matches with your audited financials. That has to be ensured. Now moving ahead with aging of loans. So aging of loans means the length of time for which a loan or outstanding amount has remained unpaid as on the reporting date. This is also very important, in which you will need the finance team help, because they will be in a better position to provide you the details of aging of loan. And in this category, please be ensured that if there is an advance from customer and you're putting it within 1 to 3 years, that means it has exceeded the 365 days, which is a non-compliance. So putting amount in aging of loans in right category is also very important. One major important thing is in Rule 16 of the Company's Acceptance of Deposit Rules 2014 requires that information in DPT3 be furnished on the basis of duly audited data by the auditor. However, we all know that statutory due date for filing DPT3 is 30th June, which well precedes the completion of finalizing of statutory audit by most of the companies. So DPT3 is typically based on the provisional figures derived from the books of account as at year end. I would suggest that we go and check the amounts, get the categories corrected with the help of auditors also. Otherwise, at the time of audit, they may have any concerns. And in this stage, even the help of professionals, CS, also comes into picture, because they will be in a better position to tell which amount should fall into which heading, which is a correct heading as per law, so that there is no non-compliance. One important thing is no certification required by practicing professional. So this is not required to be certified by a practicing professional. Director, CS, CFO can sign Form DPT3, but it makes more important for the company to ensure that the details are checked by the professional, so that there is no mistake, since MCA portal does not allow any option to revise Form DPT3. So once the form is approved, it cannot be revised. Therefore, utmost care should be taken while preparing and verifying classification, aging of loans, outstanding balances before submission of Form DPT-3. There are many penal consequences in non-filing of Form DPT-3 also, which is covered under Section 450 of the Act. For the company and the officer in default, the minimum penalty is 10,000 and continuing default 1,000 per day, whereas the maximum is 2 lakh for the company and 50,000 for officer in default. I always say one statement, which is, if you think compliance is costly, try doing non-compliance because the penalty is quite high. Moving on, let's review the disclosure and instances of non-compliance identified under other applicable sections. Disclosure in the financial statement under Rule 16A of the Company's Acceptance of Deposit Rule 2014, which requires that in the financial statements, every company other than the private company shall disclose money received from directors, whereas for private company, money received from directors and their relatives both are required. Section 134. So the board report must disclose the details of deposit accepted during the year, the defaults, if any, made, repayment of deposits or payment of interest, deposit remaining unpaid or unclaimed. Any amount received from a director of the company and related of the director of a private company is also required to be disclosed in the director report. This is the only point in which director report is required to mention about the borrowings. Otherwise, there are other sections which requires money to be given by the company. Non-compliance of deposit, implication under other sections of the Act. Please be very careful. It's a critical section which leads to penalties and non-compliances on other sections also. First is disqualification of directors. So if a company fails to repay deposit for over a year, its directors may be disqualified from being reappointed or appointed in other section because they will have to vacate their position. And then is Section 186, subsection 8, which talks about loan and investment by company which is in default and repayment of any deposit or interest thereon shall not give any loan, guarantee, or provide any security or make acquisition till such default is subsisting. Of course, if you're not taking money as per the compliances, then you're not even allowed to give money. So this is one of the restriction under Section 186. So as we have seen, that deposit section is very important because there are non-compliances which are linked to other sections also. So I would request the company, the directors, professionals, everyone who has joined this webinar to be very sure while reclassifying the section so that compliance is met. And with this, I would like to end this presentation. Thank you everyone for your time. I hope this presentation was able to provide clear insight into this topic. Thank you. Thank you, CLR.
Okay, so while Sneha's presentation is ended, but the webinar is still going on. Thank you, Sneha, for clearly articulating this summarizing the exempted deposits, the requirement of the returns, the penalties in this section, penalties in other sections. So thank you for summarizing the whole topic. Diksha, are you also there? So may I invite Diksha and Sneha both to be on the camera? Right, perfect. So thank you both again for greatly summarizing things. And now, Sneha, you ended with thank you, CLR. CLR. So, okay, the chat box is now open. Let me ask, does anyone know what is CLR? Except the eMinds folks, you please do not put anything in chat box. Of course, you know, but to the outside fraternity, the company secretaries, does anyone know? You can put it in chat box, not in the Q&A box now. The chat box is open. Anyone understand what is CLR? It's corporate law referencer. Okay. Okay. So two people write corporate law referencer. Okay. Any other interpretation of CLR, or is that corporate law referencer? What is corporate law referencer? Anyone would like to type? What is corporate law referencer? Looks like a book, isn't it? Okay, it's a no-brainer. Okay, so let me just share the the special announcement which I had said. Let me just share my screen and also share the announcement. Can you see my screen as well?
Yes, we can.
Putting it on slide mode. Yes, thank you, CLR. That's where Sneha ended. So yes, friends, this is it's my pleasure and honor to be able to launch or announce the launch of Corporate Law Referencer, which is the 12th edition of Corporate Law Referencer. And indeed, we got our author copies yesterday from the publisher. And this is the webinar that we were holding today. So what better a place than today to launch this Corporate Law Referencer? May I also, before that, give me a second, I'll co-opt one senior partner and one partner from eMinds. Let me just find them. Preeti Pahava. Okay. Preeti, you're there. And Chandan Narang. Okay, I've promoted both of you to panelists. Can you just switch on your cameras, Preeti and Chandan? Yes, we can see Preeti. Yes, Chandan is also coming. Let's just hold for a second.
Hi, everyone.
Yes, Preeti, we can listen to you. Chandan, are you there? Okay, in the meantime, while Chandan is coming, yes, Chandan is also here. Chandan? Yes. Okay, so let me just introduce Preeti Pava is a senior partner with eMinds Legal with again 25 plus years of experience. Incidentally, she shares the same surname as mine. I'm Sumit Pava, and on a lighter note and on a serious note, she's my wife as well as the partner with eMinds Legal. Chandan is also a partner with eMinds Legal with 18 plus years of experience, and both Preeti and Chandan lead the strong 40 plus team of company secretaries at eMinds Legal. And then there are other partners and other teams comprising lawyers and chartered accountants led by other partners. Okay, so let me now again share my screen. And so this was Corporate Law Referencer. And let me now go to slightly more details. Talking about this book a little bit, very briefly. And by the way, we'll just take a few minutes, and then after that we'll take FAQs. There are a lot of FAQs put in the Q&A box, and we'll be doing FAQs. We'll be answering every single question put in by you, and we'll just take a few minutes on this. So it's a 360-degree view on Companies Act and LLP, including section-wise arrangement of all circulars, orders, rules, notifications, including procedures, FAQs, resolutions, adjudication orders, and judicial precedents. It's a 12th edition. The first edition came in the year 2013, right when the Company Law 2013 came. And every year, in every April or May, we have been coming out with the revised editions. And these are the USPs, annual editions, updated editions. Section is the king. Everything is arranged section-wise. So all the circulars, orders, rules, notifications, everything is under the section. So Companies Act is 430 sections and period. There's nothing more, nothing else. Everything is below the section. There are 250 plus procedures mentioned here, 23 quick reference tables, 800 plus FAQs. Now, friends, we at eMinds Legal keep getting client queries, keep solving client queries, addressing gray areas, practical issues. All our practical knowledge is put under the relevant section in form of an FAQ. And this book is a Bible for our practice, and all our knowledge and experience we have sort of condensed and put it into this book, all available to you at a very sort of reasonable cost all across India in all leading bookstores. There are 250 plus key judgments put in by our legal team. And these judgments are by Supreme Courts, High Courts, NCLATs, NCLTs. And these judgments are not just for the sake of repetition of what is already said. Any judgment which enhances the interpretation of law have only been included, not otherwise. So all these also enhance the interpretation. 100 plus draft resolutions, secretarial standards, listed company compliances, 100 plus adjudication orders issued by the ROCs, and of course the updated Companies Act, LLP, including amendments made by the Mediation Act. So this is what is comprised in the 12th edition of 2026. This is updated up to 1st April 2026. And this is like your collector's edition. This is one book which you have to buy and keep it as your repository every single year, like a collector's edition. And this is, as I said, in the last 11 years, this is the 12th edition. And every single year, it's a commitment of the firm to be coming out with revised editions. And I'll also be happy to share with you people who have contributed. I'm, of course, I'm the lead author. You can see my name here. But other than me, there are,
Recording in progress.
Other than me, you can see Kapil Sharma, again, partner with 25 plus years of experience. Preeti Pava on the call, again, CS lawyer, 25 years of experience. Chandan, 18, 19 years of experience, again, partner. Sneha, again, panelist today, associate partner with 12 plus years of experience. Varun Sharma, lawyer, 11 plus years of experience. Swati Ajmera, 15 plus years of experience. Diksha Pahuja, again, panelist on the call, 7 plus years of experience. This is our entire team, Kashika, Rahul, Vanshika, Divyam, Shivangi, Shruti, Manoj, Himanshu, and Kushbu. So 18, 19 contributors to the book, all working with eMinds Legal full time, and all with varied years of experience, right from 2-3 years to 25 years. This is the team at eMinds Legal who has contributed to the book. And now with this, if I may, I'll just stop share, and I may request Preeti to sort of do a unfurling of the book and do a formal launch here on behalf of the entire firm.
All right. Thank you so much, Sumit. While you detailed brief about the corporate law referencer, it's my proud privilege to unfurl, to launch physical copy of the book, of course. So for people who are attending this online, you can see the physical copy. These are the
So maybe have a huge round of applause by everyone who is on the call. Even if you're on mute, we can
virtual applause helps. This is such a proud moment. A lot of effort has gone by the team in preparing, in updating this book. Like Sumit said, it's a 12th edition. This is updated up to 1st April 2026. Heavy book, of course, a lot of content in this. A lot of our practice has gone into this. I would urge all of you to take a copy, enjoy reading this book, enhance your knowledge, suggest any changes if you want for the next edition. We'll be happy to consider. And over to people now buying this book. It's available online. It's available. You can place the order with us. The details can be shared, and enjoy reading the book.
Yeah, it's available on Amazon, available on all leading bookstores, available with your booksellers, distributors, whoever. And it's also available on corporatelawreporter.com. We'll be sharing the links by email to all the attendees and participants. And over to Chandan. Chandan, if you'd like to mention anything about the book.
Yeah, Sumit.
One sec.
Yeah, am I audible?
Yes. Yeah, you're audible.
So basically, this book is very close to our heart, not only because the entire team puts in a lot of effort in updating it, maintaining this consistency is very relevant as we feel. But also because, when we hear from people who are using it, that how much value this book adds to them. When we hear from the fraternity, when we see that even the law firms, tier 1 law firms, even using our book for reference whenever they have to advise to their clients. So this gives a lot of pride to us, and therefore, we always endeavor to, be on time, always be, available with the fresh edition in April or May each year, bringing up all the, updations, additional FAQs, QRs, adjudication orders. There are more than 100 adjudication orders, also 250 plus judicial precedents, updated till 1st of April also. So anything and everything which we do and we practice, we kind of put it into this book, so that it helps not only our own clients but overall in general the overall corporate world. So very much proud moment for us to bring this 12th edition again to the people. Yeah.
Thank you, Chandan, and thank you, Chandni, Pulkit, Mr. Bajpai, for mentioning the name. That means also you're aware and maybe using. Thank you, Gaurav, for writing. I'm using this book for last 10 years, and it's a wonderful book. Thank you, Gaurav, for writing that. And okay, so you can be on mute. I'll share my screen and just one or two more things, and then we'll go to FAQs. Okay, so this was the book. A little bit again, 10 seconds about the firm. So corporate secretarial is one core part of our competency because of the book and because of the strong team of 40 company secretaries. Then legal, we got a 13-14 lawyers team who are into advisory, opinion, agreements, drafting, wedding, IPR, and litigation. We are handling some 3,500-4,000 cases as well on recoveries, mediations, arbitrations, etc. Then we got compliances, compliance audits, compliance advisory, opinion. Then a full-fledged team of chartered accountants specializing in accounting, taxation, payroll, India entry services, and the latest vertical we've opened is the CS recruitment, specializing in CS recruitments and trainings of soft skills and emotional intelligence. So that's about the firm. Then Complinity, as I said, is our India's leading compliance software, adding value to more than 1,500 companies all over India. This is the latest venture, eMinds Foundation, which is an NGO with a heart, where we are channelizing CSR contributions of our clients and channelizing it into healthcare and education primarily. And in case you would also like to associate with eMinds Foundation, we can help you put the funds in the healthcare or education sector in the right NGOs, do the due diligence for the NGOs, and give you utilization certificates and all above board. Sometimes the challenge comes is that you have the funds and you have to deploy them in CSR, but you don't have the bandwidth or the time or the knowledge to see where to invest money, and therefore you may end up putting it in PM National Relief Fund. While no offense to that, I mean that's also a great fund. But then here you can actually, if you spend through eMinds Foundation, we will be able to help you identify the right NGOs and put the money where you can actually relate how your money is going in and how that is being utilized, to help the needy. This is our team, 62-63 people team, powered by intellect, driven by values. All company secretaries, lawyers, chartered accountants in one roof. And these are some of our clients. You can see nice, good clients, good logos. And these are the partners, as I said, myself, Kapil, Preeti, Sandeep ji, Chandan. And here are the contacts of Preeti and Chandan as subject matter experts and senior partners and partner of the secretarial practice. And this is my contact if you would like to be in touch with me. I'm very active on LinkedIn. So you can just search Dr. Sumit Pava on LinkedIn and you will find me. And, please give me a connection request and I'll be happy to connect on LinkedIn. So that's about the presentation. And I'll also unshare my screen. Give me a second. Yes. So now, Chandan and Preeti, I'll be making you like an attendee again. And we'll go to let's go to the FAQs now. You can switch off the chat box, Nandita, and there are a lot of questions which have come up. And so Sneha and Diksha, I'll be moderating the questions. Anyone can answer. Please keep your mics unmuted, and whoever feels like you, please answer. So starting from first question, Gaurav. Gaurav asked, CGTSME amount received is insured by government. Is it exempted? Is it exempted deposit?
So in case the repayment is guaranteed by the central government or the state government, then it will be exempted.
Then it will be exempted deposit, right? Yes. But it is an exempted deposit, so it needs to be reported in DPT 3 as an exempted deposit, right?
Yes.
Okay.
Welcome to Complinity Technologies. Complinity is India's leading governance, risk and compliance software helping companies to manage their compliance, contracts, litigation, legal updates, inter-financial controls and more. Complinity is a one-stop shop for all GRC needs. With our proprietary 12 GRC modules and real-time legal updates on 2,000+ laws and 24,000+ compliances. All in an integrated platform that is easy to use with automated alerts and risk management capabilities. Is why compliance managers, general counsels and chief financial officers choose Complinity every time. Join the most innovative and prestigious brands that use Complinity. Automating your compliance management. Request a demo at complinity.com.
Okay, next is, if a company does not have any deposits or loans, should we still mandatory file a nil or a nil return in Form DPT 3?
So
That
if they are, Diksha, can I take this?
Yeah, your voice was not coming. Sneha, can you repeat?
So if there is opening balance, I think there is some issue. Am I
Yeah.
audible now?
Yeah, audible. Yeah.
So if there is an opening balance in the beginning, then you have to report it, even if there is. Straight. Diksha, can you continue? My voice is echoing.
Okay. Okay, we'll hold that question for Sneha. Sneha, that question is reserved for you. Next, Diksha, Arpit asks, is it applicable to file DPT3 for an NBFC?
No, it is not applicable, as we have already mentioned that NBFC are exempted from the compliances of deposit rules, so they are not required to file the form.
Right. Sneha, just alert me when you're ready. So Shekhar asks, an advance received from customer for participation in an exhibition to be organized after 1.5 years and outstanding in the books for more than a year as on the year end, will it be considered as an exempted deposit?
So you can take the advance only for the 365 days. If it is going beyond that, then it is not allowed. This will become a deposit then.
Yeah, then this will become a deposit because, as you're saying, advance has to be adjusted within 365 days. But sometimes maybe in international exhibitions, organizers may be taking well in advance. It may be a large conference, and if the payment terms itself are like you pay now, but the conference is after 18 months, still it'll be like that, Diksha, exempted, not an exempted deposit.
Then you have to make the arrangements in such a manner that you are not taking it beyond, it is not going beyond 365 days. That is the condition.
Yeah, that's what the law says, unfortunately. Yeah, 365 days or 1 year is the limit. Okay.
I would also like to add, basically, the law is made for the general businesses. It is not made tailored as per different businesses.
Right.
So, though it is a practical situation, but still we only have 365 days.
Perfect. Okay, Sneha, so good. Glad to see you're back. So, Sneha, the question which you were answering was, if a company does not have any deposits or loans, should they still mandatorily file a nil DPT3?
So if you have the opening balance is also nil and the closing balance is also nil, then you're not required to file form DPT3. But if you have an opening balance but not the closing balance, then do file form DPT3.
Understand. Yeah, because the return, as you were showing, has an opening balance as well as a closing balance. Yes. So if any of the balances has a number, then you must file it, right? That's what you're saying.
And it is also important, Sumit, to like if you have filed form DPT3 in the previous year and have reported a closing balance, which becomes an opening balance in this year, it also becomes important for ROC to know that now the amount is not there.
Right. Perfect. And also, Sneha, I was noticing when you were presenting that the words used in the return are loan. While, Diksha, when Diksha presented, there were 17, 18 categories of exempted deposits. But the amount, the word used in the return is loan. So would you like to, elaborate on that?
Yes. So basically, when the form came into picture, there were some few amendments few years back. The form says loan, but if you will go through the help kit or the law, it does not require only the loan amount. It requires any amount. So that is why I also clarified during my presentation. Please don't get confused that only loan amount is required, because in the left hand side, there are various categories of exempted deposit which talks about other than loan amount also. So that has to be taken care while filling the form.
Okay. So now another question is whether any loan from LLP, HUF, Karta of HUF will be considered as deposits?
Okay. So LLP is not coming under any of the exempted categories. So if you are obtaining a loan from the LLP, then this will become a deposit since it is not covered in any of the categories of the exempted deposit. And from Karta or HUF, it will depend on the status of the company, whether he is a director or he's falling under the promoter category. So that will depend on the status of the Karta or the individual.
And if he's neither a director nor a promoter, etc., then it will be straight away deposit, right? The private companies cannot take that.
Yes.
Perfect. Okay. Next is with respect to 0.6 exemption. If the amount received as advance from the customer who is a registered company, then it is exempted. But if the customer is not the company, then will it be considered as deposit? So his question is, if the advance is being received from a company vis-a-vis a non-company, is there a difference?
So the company is covered, from any other amount received from a company, it is straight away allowed. But from a customer which is not a company, then you have to see the condition that we have already mentioned, that an amount received from a customer against the supply of goods or services. If it is falling in any of those categories, then it will be exempted. If not, then it will not be.
Yeah, I think in my opinion, whether it's a company or not a company, but if it's for goods and services, that's what the query is. If it's for goods and services and it's within 365 days, irrespective the other party could be a proprietorship, partnership, company, whatever, it would still be falling within those exempted deposit definition, right?
Yes, that's right.
Yeah. Okay. So Sneha, for example, another question is kindly explain the process to be done once the amount is considered as deposit from exempted deposits. Although that's not the topic of the session, but at a high level, if you would like to say something about it.
So basically, in the exempted categories also, there are few amounts which are allowed to be refunded. So for example, if it's a share application money and for some reason you cannot refund back you cannot basically allot shares, then we have a time period of 15 days to refund it. And for the advances also, there is a time frame of 15 days. So if the amount has fallen into that category, please refund the amount. Otherwise, it's a non-compoundable offense. There are penal provisions which has to be ensured. That is why we as eMinds follow a practice of keeping check every month, asking the companies about the details, so that beforehand we are ready to appropriate the amount in the correct headings and non-compliance is saved for the company.
Right. Let me also, in the same breath, show you something, show the audience something I would love to show here. Is my screen visible, Sneha and Diksha?
Yes.
So, for example, this is a chapter from our book only, the current 12th edition, Acceptance of Deposits by the Company. So, on this question, one second. Can you confirm, is my Q&A also visible? It should not be, but is it visible, Diksha and Sneha?
No, only the file is visible.
Only the file, not the Q&A. Yeah, that's what I wanted. Okay. So this is this section 73 says prohibition on acceptance of deposits from public. So this section is on deposits, right? So this is what it, and then the exemptions and stuff like that. So if from exempted deposit it becomes a deposit, then I think this section and the related rules have to be sort of seen of what all needs to be done. So I just wanted to point your attention to the whole chapter here. And also now again coming back to the book for 1 second, you see section 73. Then below the section, there's again an extract from the book only. You see the applicable rules, whatever cut out of the rules is applicable to this section has been mentioned over here. So I'll just quickly scroll down. The entire rules are here. Since the rules are quite detailed, so I'll scroll down very quickly. You can see all the rules, but it's not the full rule. It's the whatever is applicable to 73 or below section 73, right? Then below the rules, if there's any cross-referencing, we refer that also, refer so-and-so section under NCLT. Otherwise, all the circulars issued under section 73 are down here. Clarifications, right? All the notifications, clarifications, circulars, even orders. If there is any ROC adjudication order, that will also come here. If these are the applicable notification. If there's any judicial precedent under this section, that will also come here as judicial precedent. Then this is quick reference. It's like a procedure. So you can see these are our editorial remarks. So applicability, compliance checklist, all this goes point by point, checklist wise. These are all our editorial inputs under the section. Applicable forms, website disclosure, newspaper advertisement, penalties, registers, listed company compliances with respect to section 73, certain more eligibility thresholds, etc. All this is below section 73. Then the FAQs, as we were saying. So you see, all these are FAQs which may have been asked from us in the previous or they would have either been asked by some clients or our teams would have thought of these questions. See, these are all the FAQs. Just for example, whether NBFCs. So this was a question here also, right? Whether NBFCs are required. See, it says these rules shall not apply to an NBFC, so and so, so and so. So, different questions, different answers. And, we keep adding these FAQs, and you see judicial precedents also. Amount advanced by a director is treated as a deposit in terms of section so and so, and you see a citation. There's a relevant extract from the judgment, and then there's a citation here, right? So this is how and then section 74, and then it'll continue. So I wanted to just impress upon you, this is how the book is structured. Everything is under that section: circulars, orders, rules, notifications, precedents, FAQs, procedures, resolutions, everything is like that. Okay, coming back to the next question.
Sumit, I would also like to add something regarding this book only.
Yes.
So basically, this is one of the pain area for professionals, because whenever a company needs money, everything is on fire. The money
Yes.
has to be received within 1 day, 2 day. And on the MCA website, sections, acts are in different categories. So you rightly mentioned before that this book is a Bible for a lot of professionals, because we have the section, rules, Q&R, FAQs, as well as the adjudication orders and circulars. So everything is at one place. So chances of missing a compliance is very less.
Right. Okay. So now next question is, please explain the concept of the aging of the loan of years 0 to 1, 1 to 3, etc. as displayed in the form DPT3. Maybe Sneha, you would like to again answer that.
So basically, aging of loan is categorizing your loan on the basis of risk factor, on the basis of repayment amount, and it is usually mentioned in MIS report of a lot of companies. So any amount which is received in aging of loan, you have to categorize in how much time will it is required to be even returned back, outstanding amount and all, so that company is also well aware that what is the bracket in which that amount has to be returned back to the lender.
Understand. Okay, so Diksha, now over to you. Amount received from director as a loan in September 25 and paid back to a director in March 26. So maybe before the end of the financial year. Will it be treated as deposit and to be shown in DPT3?
So the amount will depend whether it is a private company. Yeah. So private company and public company, any amount received from a director is an exempted deposit. So this will not treated as deposit. How also, if you have received it during the year, the opening balance will come, and the amount repaid during the year, you have to also report it in form DPT3, as Sneha has already shown in her slide. And the closing balance will be 0. So you have to report the details in form DPT3.
Yeah, no, but the question is the amount was received during the year and repaid during the year. So there's no opening at the beginning of the year and no closing at the closing of the year. That's the question. So received during the middle of the year and repaid also in the middle of the year. Will that be reported?
Yes, because you have to mention the amount that which is received during the year, and also if you are repaying during the year also, then it will be shown in the adjustment and the closing balance will 0. So it will be reported in form T3.
But again, I'm sorry for extending this. Sneha, if I may have your views as well. There is no opening balance, right? So your return format said opening balance and closing balance, right? Those were the columns. Or there was another column called during the year.
Two more columns. There were two more columns. Okay. It was also related to additional amount received and repaid during the year. So opening balance will come as 0. Additional amount will put 10 lakh, and then repaid another 10 lakh will be. So closing balance will
again be 0. Yeah. 0. Okay. Yeah, I agree. I agree with both of you. Done. Okay. Next is, see, this is how we debate at eMinds Legal. Until the query is absolutely clear, we will continue asking and debating. So thanks for all your questions, guys. I'm again continuing with the questions. Vivek asks, relatives means, is it referring to the RPT category? Related transactions?
Definition of relative is defined under the Companies Act. You have to refer to the definition of relative under the Companies Act.
Right. So it becomes a related party transaction, right? Any which ways. Also. Okay. Kanav asks, can a NRI invest in Indian startup? Means if they invest in Indian startup, is it considered an exempted deposit?
Yeah,
so for startup companies also, amount is allowed to be taken from NRI, but you have to comply with the FEMA compliances. So ensure that if you're taking any loan amount, then the guidelines of FEMA compliances are also met.
Okay. So I think I'll have to ask, both of you are bubbling with energy and knowledge and confidence. So I'll have to now because there's no fastest finger first over here, right? So Sneha, whether filing of nil DPT3 return is mandatory?
No, it is not mandatory, but you have to ensure that there is no amount only, opening balance, closing balance, and just mention additional amount and repaid amount. If there is nothing, you don't have to file form DPT3.
Okay, Shekhar also asked the same question. Sakshi asks, please confirm whether the details mentioned in DPT3 are based on the audited financial statements, Diksha?
Yeah, the law requires that the figures that you are entering in form DPT3 should be based on your audited financials.
Understand. Now, so I'll alternate. Okay, one question Diksha, one question Sneha, and anyone can pass also. That becomes a game then. Anyone can pass also. Okay. So now Shilpi asks, in which section to disclose DPT3 loan taken by a private company from an LLP?
That's not allowed. That's not in the category of exempted deposit. So private company cannot take loan from LLP only. Otherwise, it will fall under deposit.
Okay. Gaurav asks, the limit of 25 lakhs in startup, how do you... The question is not very clear actually. There's some typo errors over there, so I'm not able to sort of... Gaurav, you may actually type your question again if you're available right now. Okay, Rakhi asks, will we get the recording? Oh, yeah, that's a question to me. Will we get a recording of this webinar? I missed 1 hour of webinar. Yeah, Rakhi, though you joined late, but yes, of course, we'll be sharing the recording. Though it's not, it's like when a movie screen in theater, you can see there and then. It comes on Netflix after some time. So yes, after a few days, it'll be there on the YouTube. We'll just subscribe to our YouTube channel right now. LinkedIn, YouTube, just subscribe to all channels. You'll surely be notified then. Okay, everyone, this is a request to everyone. Okay. Then next is, should customer advances be paid off within a year? If not, is it a non-compliance? I think the answer is yes, because only 1 year are exempted deposits, rest become deposits. Yes. Either repay it or you avail the, means give the services to the customer within 1 year. Okay. Amount held in trust without interest. Does it mean if company receives amount from anyone without interest, will it be exempted from considering a deposit? Anyone?
So actually this point is not detailed in the law also. It mentioned any amount received by the company and held in trust, means an amount which is not required to be paid with interest. But detailed explanation is not mentioned in the law. Some people consider it as a trust in the form of trust and somebody in good faith. So this is one of the gray area in the law also, where details are not mentioned.
Okay. Now Suresh asks, are the 365 days counted from the end of the year? I'll only answer this. No, they are not from end of the year. They are from the date when you receive the advance. So every single transaction, 365 days have to be treated from that, right, Sneha and Diksha?
Yes.
Yeah, there's no concept of year over there. Gaurav says, can ICSI make a recommendation to file DPT3 as per AOC 4? So Gaurav, I think you please approach the Central Council or any other council member whom you know, or maybe write to president@icsi.edu and give your suggestion or any other contacts you may have. Then Saurav says, whether loan from a promoter or shareholder will be a deposit. So exemption was already given in the exempted deposit, Diksha, right?
Yeah, if it is pursuant to any stipulation of any financial institution, then it will be exempted.
Only for a stipulation, not otherwise, right?
Yeah, otherwise there are certain conditions under the deposit rules that there are certain limits for the private company up to what percentage they can receive the loan amount from the promoters or the shareholders.
Right. Now Balaji says A was a director shareholder of a private company when he gave a loan to the company. On his demise, the loan was transferred to his son, who is only a shareholder, not a director. It's a very specific case. So where is it to be disclosed in DPT3?
So basically, in this case, the law only allows amount to be received from director. So if his father has demised, the amount should have been returned back to the his son, and it cannot be transferred. That can only be transferred if he himself becomes a director, and then the money is taken, because law specifically say at the time of the receipt he should be the director of the company.
Yeah, so I think, Sneha, in my opinion, I would say that when the money was received, he was a director and shareholder, so money was legitimately received under the rules. Now, if the said person has expired and the loan has been bequeathed to the son, I don't think there is any non-compliance, and I don't think it will continue to be an exempted deposit, even if the loan is now the beneficiary of that loan, of the return of that loan is the son. But I don't think there is any non-compliance, and it will continue to be an exempted deposit.
You rightly said, Sumit, but actually these are specific practical cases, and it will involve a lot of clarification also to the auditors, to the ROC, which becomes very difficult for the company as well. So it is, of course, suggested not to fall into if you do not fall into any of the category, then it's better to return back the money.
Sure. Okay. And Balaji, if you need some detailed analysis and opinion, you can surely consult eMinds Legal, and we'll be happy to explore, evaluate, and give you a legal opinion if required. Okay. Chandni asks, what shall be the complication if an amount is considered and reported as a deposit? I think no complication is just that follow the deposit rules, I would say, means, but they have to be followed before the deposit is accepted, not afterwards, right?
Yes, that's right. You have to make the circulars, issue the circulars, you have to appoint the debenture trustees, and so on. There are multiple compliances that you have to ensure before taking any amount which is not falling under the exempted category.
Yeah, before taking an amount. But if you take any amount thinking it's an exempted, but it ultimately came out to be a deposit, then you are running into problem, and then the penalties and consequences which Sneha was articulating, Sneha, that would be applicable, right? Then you may have to go for compounding and all. Yeah. Okay. I'm conscious of the time. It's 1:29. There are still a few questions which are unanswered. I'll just very quickly try and cover. Okay, so Gaurav has written again, 25 lakh limit is per tranche in case of startup under exempted deposit. Why do you think the amount of 25 lakhs is there? So it's I mean, it's not for the speakers to comment or for anyone to comment why 25 lakhs. I mean, why the law is the way it is, we can't comment, Gaurav. So I mean, 25 lakhs is neither too less, not too much. And convertible notes also, the section under convertible notes also mentioned 25 lakhs as one threshold. So there are so many thresholds under the company law, CSR has its own threshold, audit committee has its own threshold. So there are many threshold-based compliances. By the way, we have another table in the book on threshold-based compliances. So again, thresholds are what they are. What's the intent of the legislature? Okay. Saurav says, if a company receives loan from director multiple times in a year, whether he has to give declaration each time?
Yes, that is absolutely required.
Right. Okay. Let me see. So we'll take 5 more minutes maybe and try to see as many more questions. Guys, if you are enjoying and liking this, just be with us for 5 more minutes and we'll try and cover a few more questions. I'm just sorting things. Okay, somebody asked regarding advance towards consideration for providing future services, will the amount be considered as deposit if I don't avail the services?
Yes, the amount is to be utilized as per the terms and conditions. If you are not complying with the agreement, then it will be considered as deposit.
Right. Now, in case of real estate company received an amount pursuant to the unit booked in a project which will be delivered in 2 to 3 years. Interesting question. Because real estate, you have construction link plans and unit will be delivered in 2 to 3 years. Now, it's also an advance. But I think, in my opinion, and you may please correct me, Sneha and Diksha, I think it's not an advance only. The payment plan is such that, okay, 30% say on booking, another 30% on some slabs, etc. So the first 30% is not an advance. It was the payment as per the milestone. It was a payment which was due, and it is deemed to be consumed. And there and then it's not an advance only, in my opinion. So any other opinion, Sneha, Diksha?
Yeah, so we have already covered in the exempted deposit that any amount received against the immovable property, if you are complying with the conditions, then it is allowed.
Yes, it's already there in the section language also, right? Real estate
for the immovable property covered in the advances.
Right. And I think what I explained is also the logic of it, right? Because real estate projects go for 4 years, 5 years, and those are typically not advances; those are payment milestones only, right?
Yeah.
Okay. Then let me see. Shilpi says, what compliance needs to be ensured in case of advance from foreign entities for research services exceeded 365 days due to time taken for research?
Okay. So basically in FEMA Act also, we have current and capital account transactions. So if you're following the law, then even if it is exceeding 365 days and complying with the FEMA law, then it is allowed.
Right. Perfect. Okay. Then we have one more question from Anushil. I have observed that SEBI registered brokers generally transfer the unutilized balance lying in a client's trading account to the client's linked bank account on a quarterly basis. I would like to understand the rationale behind this practice. I don't think is relevant to the topic, right? So maybe Anushil, the question is good, but then it's slightly outside the scope today. So we may have to, I mean, if you need some opinion, you please consult with us offline. We're happy to help you. Now, somebody says regarding advance towards consideration for providing future services, will the amount be considered as deposit if I think that was covered. I'm sorry. This was done. For a newly incorporated company wherein INC 20A is still to be filed for opening bank account, the director deposited 50,000 as per bank norms. How to treat the same in books? The company will pay the same once subscription money from MOA subscribers is received. Anybody?
So I'll take that question.
Yeah.
So basically, it also depends upon how the amount is being treated in the financials. If it is being treated as reimbursement, for example, directors also take an amount from the company and keeps on spending on the travels also, for which they give their bills. That is basically sort of an impressed account. So in this also, there are a lot of banks also which ask the directors to put 30,000, 40,000 rupees as a amount which is a minimum balance to be maintained. But as and when the subscription money is received, ensure that the amount is refunded back to the directors. And in the books of account, that amount should be treated as a reimbursement to directors and not as a loan.
Right. Perfect. Thank you, Sneha. Now, there's another case study, a slightly longer one, but I'll very quickly say, Mr. X, director of a private company, gave unsecured loan to the company. Later, he gifted his shares in that private company and loan to his son, Mr. Z. I think it's a very long question. I think we'll skip this one. Kapil Datta. If required, you can mail it to us, please, at you can say contact@emindslegal.com. Nandita, if you can mention that in the chat box, contact@emindslegal.com. Any further queries on this one, and we'll be happy to answer. Now, okay, one question interesting in a jewelry industry. It says, we are from jewelry manufacturing and retail seller company. We used to collect monthly plans or scheme for stipulated period from the employees and customers and ask them to use it for purchase after maturity with some additional benefits as per the terms. I'm aware of these schemes. My wife also kept telling me, but we never subscribed to such schemes. So is it considered as an exempted deposit or a normal deposit? So jeweler taking amount from people saying, okay, you keep giving me monthly sort of amount. These are all unorganized practices, I would say. Then is it exempted deposit or a deposit?
No, I think this will be covered under the advances from the customers. So you have to make the payment or the adjustment within 365 days. If not, if it is going beyond 365 days, then it will be a deposit.
And
yes,
I would also like to add in this thing. So I have also worked with ROC. That this was one of the case which we also analyzed for one of a big jeweler company. And after the penalty was imposed on them for this, actually, if you'll see, the jewelers have started changing their practices. Now it is 11 months, and in the 12th month, you have to buy.
Oh.
The case, because of that, everything changed. So it is only allowed till 365 days. Otherwise, it is considered as deposit for jewelry making companies.
Perfect. Thank you. And I think in the interest of time, there are a few more questions unanswered, but then, okay, we'll consolidate this. And if required, we can also try and incorporate these in the book. We can publish it on LinkedIn. So please follow our channels and we'll be happy to do that. There are a few questions from our eMinds champs. Again, Mohit Malhotra, acknowledging Mohit Malhotra, Vivek Sundrial, a couple of questions from each one of them. So recognizing and acknowledging your presence, Mohit and Vivek, but since you have access to the speakers face to face, I would encourage you to please catch up with these people on a water cooler conversation and get your doubts clarified. Okay, on that note, friends, thank you very much for attending in good numbers and staying even 5 minutes past the webinar scheduled webinar ending time. Thank you for being part of our launch of the Corporate Law Referencer 12th edition. Thank you for all your love and support. Thank you for subscribing to Corporate Law Referencer, subscribing to webinars, and I hope you enjoyed. And yes, the recording of this will be available on YouTube. And I'll just do a closing poll. Just give me a second, and then we will end the webinar. One small poll. Okay. 1 second. Closing poll. Yes. Okay, so if you can now say, would you like to have a demo of the Complinity compliance software? As I explained, it's India's leading compliance software helping you comply with the laws and all the laws, company law, GST, income tax, labor laws, including the new labor codes, DPDP, including the new DPDP Act, rules, regulations, notifications, 3,000 laws we are covering. So if you would like to have a demo of this software, please say yes. My teams will be happy to reach out to you. And also, would you like to order a copy of Corporate Law Referencer? If you just indicate your preference, again, our teams will reach out to you and share you links with some special discounts. And okay, we'll arrange some special discounts for the webinar participants today. Just indicate yes, and you'll get a special discount and free shipping all over India. And the links of YouTube, LinkedIn, requesting a demo are all on the chat box. My LinkedIn link is also there on the chat box. And by the way, I'm a PhD in emotional intelligence also, and I keep writing regularly articles on emotional intelligence and leadership. So if you would like to connect with me, you'll keep receiving some of the as a feed some of the stuff that I write. So please connect with me. Happy to be in touch with you. Okay, on that note, thank you to our speakers, Sneha, Associate Partner, eMinds Legal, Diksha, Senior Associate, eMinds Legal. In absentia, thank you to Preeti Pava, Senior Partner. Thank you to Chandan Narang, Partner, for coming for a short while for the unveiling of the book. Thank you to the eMinds champs. Thank you to the secretarial team for giving good research support to the speakers. Thank you to the legal team. Thank you to the accounting team. Thank you, audience. Thank you, everyone, for being there with us. And thank you very much. Bye.
Thank you, everyone.
Thank you.
Welcome to Complinity Technologies. Complinity is India's leading governance, risk and compliance software helping companies to manage their compliance, contracts, litigation, legal updates, inter-financial controls and more. Complinity is a one-stop shop for all GRC needs. With our proprietary 12 GRC modules and real-time legal updates on 2,000 plus laws and 24,000 plus compliances, all in an integrated platform that is easy to use with automated alerts and risk management capabilities, is why compliance managers, general counsels and chief financial officers choose Complinity every time. Join the most innovative and prestigious brands that use Complinity. Automating your compliance management. Request a demo at complinity.com.